I don't mean, well, I do mean to interrupt, well, what if you're doing, you know that from your, the official weather, whatever, a very bad storm is coming. You also know that not everybody checks the city site, 12 times a day, but a lot of people look at your private site. And if you put on there's a very bad storm coming, or I looked at the city weather, whatever, you need to know there's a bad storm coming. Does that compromise the private nature of your page?
No, again, you haven't set up an ongoing channel for communication where people know that's the place to go in the future for important information.
Well, why do you know that this is an ongoing channel of communication? What do you look to decide that? And be specific about this site.
Sure.
What on this site indicates that this was what you consider an ongoing channel of communication, as opposed to just a place where you talk about your dogs, you talk about your children, and you talk about your work?
Sure. So I think as soon as the pandemic started, there were multiple posts a day about what he and other people in the government were doing. Usually he was going to post a daily COVID update from the basically health equivalent of the CDC. He was posting directives, so I could direct you, for instance, to the directive on page 22 of the Joint Appendix. There's another directive on page 20 of the Joint Appendix. And then the specific post that was the subject of the dispute with my client, that was flanked by a post about a community operations outreach center on one side and a place to donate for people who were struggling on the other side. So there were just multiple posts a day about this. And he was also interacting with constituents. So one of the key features I think that you would lose out on is if you go back to page 22 of the Joint Appendix, he issues this order about cutting off water. And he says, basically, effective immediately, we're not going to cut off water for 30 days because of the pandemic. And then there's a question from a constituent below who says, well, what about people whose water is already cut off? Are those going to be turned back on? And he answers yes. So there's essentially a real-time gloss on his own directive. And it's possible that the directive appeared somewhere else. There's nothing in the record about that, but it presumably came a little bit later. And if you wanted to know what is the city manager, who's essentially the chief executive officer for the town, what is he doing? That's the place to go. There was essentially no other game in town for figuring it out if you were a citizen of Port Huron.
Well, that makes it pretty difficult for a public official or city manager to have any kind of private site, because he could have a private Facebook page populated with pictures of his dog, pictures of his kids, and one of his friends asks something about the water shut off, and he says, yeah, the water's going to be shut off, et cetera, or a storm's coming, whatever. Has he then transformed what he thought was his private Facebook page into something that is state action, and so he arguably has to give everybody in the town access to, when he might not want to give them, access to pictures of his kids? Or does he have to tell his friend, sorry, I can't answer that question here, head over to my public Facebook page and I'll answer it there? So
that sounds a lot to me like the sort of Facebook equivalent of just running into someone in the grocery store. I don't think that creates any sort of channel that way. Although the best practice is obviously to refer someone, for more information, go to the official page.
Creates nightmares of litigation though, right?
So it could create nightmares of litigation. I think literally whatever you say here, unless you essentially say nothing that happens over Facebook is going to ever be state action, which I don't even now take any of the parties to be arguing. Unless you say that, you're always going to have some amount of litigation. The good news is our test has been the majority test in the circuits, and I think the reason that you don't see a flood of litigation, there are basically only 5 Court of Appeals decisions, including the 2 cases before you, is number 1, you've got the qualified immunity overlay. Number 2, most of these First Amendment claims are not going to have much to them. They can be dismissed on reasonable time, place, and manner restrictions.
Why isn't all of Facebook the equivalent of running into someone at the grocery store, unless on that personal page you're announcing some governmental rule or some official notice of some kind, and we can debate what official notice is?
So I think Facebook, as this court has said in other cases, and all of these social media platforms are incredibly powerful in a way that running into someone in the grocery store is not. This is not just an incidental place where you happen to receive speech from someone. In the olden days, if you were a public official and you wanted to communicate with the public outside of formal channels, you probably would have had to walk out of your office, maybe find a payphone if you remember what those still were. And it would have been very difficult without the use of your staff to communicate to the public in any sort of broad way. These social media platforms make that basically instantaneous. You can cast as wide a net as you want, talk to everyone in the town. You can talk specifically to individual people. They are just incredibly powerful in a way that I don't think that just the happenstance of running into someone in the grocery store is. I think the better analogy, if I may tweak yours, is essentially just saying, you know, I'm going to post my private phone number. Everyone in the town can give me a call if you have problems with your leaf collection. Oh, but by the way, only white citizens are allowed to use this phone. I think that would also be constitutionally problematic, even though you were using your own private phone number.
Thank you. Justice Thomas? Justice Alito?